All right, guys, welcome back to the channel. This will be part 2 on passports, right? Specifically, passports and the right to travel, the document created by by Congress for one of their subcommittees in 1966. Hopefully, you guys are caught up with the first part of this, which was only like 35 minutes, but I knew I had to skip some stuff, so let's read some good stuff, get rid of the other stuff, and then go. So this is the second part. This would be part 2. So to continue, it says, the rights and liabilities of citizens. A, personal liberty in the United States, the right of locomotion. We call it the right of travel and all that stuff, but it's the right of locomotion. The United States Constitution, adopted in 1789, contains no specific reference to passports. It did refer to liberty in the preamble. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. This, however, could not be used as a source of power for the enactment of any statute, which is true. It's more of a document of intent, right? It's not the document that creates powers, it's the document of intent. The body of the Constitution alone is the only source of power authorizing action by any branch of the federal government. The Fifth Amendment clothes the bare bones of the preamble with flesh and blood. It provided in part that no person shall be deprived of life, liberty, or property without due process of law. So this in itself, the Fifth Amendment, enshrined or clothed itself with what was stated in the liberty aspect of the preamble. Later, the same provision was included in the 14th Amendment as a prohibition upon the states. The Fifth Amendment, with which we are concerned, protects the individual against arbitrary action by the government, but no specific reference is made to the individual's right to a passport or right to leave the realm. The key word in the amendment, of course, is liberty. The common law seems to have been based upon the idea that no man had the liberty or right to leave the realm without the king's permission. Something in the nature of a license or permission was, in the earliest times, included in the idea of a passport. To continue highlighting that right there. By the time of Blackstone, however, this had changed. He stated that any man might leave without the king's license, subject to the right of prohibition or recall by the king in certain instances. This seems to have been the background of the ideas of liberty, which were included in the Constitution as amended. Where'd it go? This thing is really sensitive to move it up and down. In discussing personal liberty under the Constitution, Cooley, Constitutional Limitations, 8th edition, points out the qualifications and restrictions which the law imposes upon personal liberty. Sir William Blackstone says, personal liberty consists in the power of locomotion, of changing situation or moving one's person to whatsoever place one's own inclination may direct, without imprisonment or restraint unless by due course of law. It appears, therefore, that the power of locomotion is not entirely unrestricted, but that by due course of law, certain qualifications and limitations may be imposed upon it without infringing upon constitutional liberty. Indeed, in organized society, liberty is the creature of law, and every man will possess it in proportion as the laws, while imposing no unnecessary restraints, surround it in proportion as the laws while imposing, surround him and every other citizen with protections against the lawless acts of others. In examining the qualifications and restrictions which the law imposes upon personal liberty, we shall find them classed according to their purpose, as first those of a public and second those of a private nature. The first class are those which spring from the relative duties and obligations of the citizens to society and to his fellow citizens. These may be arranged into subclasses as follows. Number 1, those imposed to prevent the commission of a crime which is threatened. 2, this is those in punishment of crime committed. 3, those in punishment of contempt of court or legislative bodies, or to render their jurisdiction effectual. Number 4, those necessary to enforce the duty citizens owe in defense of the state. Number 5, those which may become important to protect the community against the acts of those who, by reason of mental infirmity, are incapable of self-control. All these limitations are well recognized and generally understood, but a particular discussion of them does not belong to their subject. So these right here are already a given, right? And these are the first class, the public class. With respect to the right of locomotion, the right of liberty, the courts have stated in Allgaier versus Louisiana. This is Allgaier in Louisiana was a 1897 case. Fears is 3 years later, and Edwards is a 1941 case. The liberty mentioned in that amendment means not only the right of the citizen to be free from the mere physical restraint of his person, as by incarceration, but the term is deemed to embrace the right of a citizen to be free in the enjoyment of all his faculties, to be free to use them in all lawful ways, to live and work where he will, to earn his livelihood by any lawful calling, to pursue any livelihood by avocation, and for that purpose to enter into all contracts which may be proper, necessary, and essential to his carrying out to a successful conclusion the purposes above mentioned. In Williams versus Fears, undoubtedly, the right of locomotion, the right to remove one from one place to another according to inclination, is an attribute of personal liberty, and the right ordinarily of free transit from or through the territory of any state is a right secured by the 14th Amendment and by other provisions of the Constitution. Now, what did they just say? There's no doubt someone's butt hurt right now from hearing that. Especially since we have gone on the theory that United States citizens don't have no fundamental rights at all. In Industrial Organization versus The Hague, that's the case I don't have up here. The constitutional guarantee of liberty includes the right of locomotion or movement, any interference with which must be by due process of law. So this is one that I will be using in a court case that I have, that I will be filing soon. So let's see if I can find this really quick. All right, there. I will be going to court listener for almost all these. I don't really care for juices here. It comes up first, so. But nonetheless. The right of locomotion, the right to travel is so fundamental that Mr. Justice Douglas felt constrained, meaning he didn't like it. He agreed, but he didn't like it, in a concurring opinion to indicate the reach of the constitutional question involved in Edwards. In this case, the majority of the court held that a California statute prohibiting the importation of indigent persons into the state unduly burden interstate commerce without considering the constitutional question of the right to travel free from state interference. Well, let's look at the wording, right? They're saying importation, right? Is that a commercial context? Indigent is what? Poor people, right? So not paupers. Paupers would mean that they are, receiving benefits and they need the government in their life type stuff, right? But importation, right? But it said it was unconstitutional because it burdened interstate commerce, right? But he was constrained in his opinion because the free exercise to travel is wasn't present. I was in without wasn't even considered. He was joined by Mr. Justice Black and Mr. Justice Murphy. Mr. Justice Douglas stated, "The right to move freely from state to state is an incident of national citizenship, protected by the Privileges and Immunities Clause of the 14th Amendment against state interference." That's in that case, in Edwards. Mr. Justice Moody in Twining versus New Jersey stated, "Privileges and immunities of citizens of the United States are only such as arise out of the nature and essential character of the national government, or are specifically granted or secured to all citizens or persons by the Constitution of the United States." Now, what did they just say? What did they just say? The most significant one is the second portion. Oh, where did it just go? I just messed up. Okay. It says what? Or are specifically granted or secured to all citizens or persons by the Constitution of the United States. What do you think they're saying here? What rights do you have secured and protected by the Constitution that the 14th Amendment, that the federal government protects? Now, they didn't state 14th Amendment here. They just said privileges and immunities. But they used, they're using this. There's other documents. I'm not going to go into it right now, but there's other documents, even recent one now, where they are construing that the privileges and immunities are the same as in Article 4. The privileges and immunities of the 14th Amendment does not include the Bill of Rights, though. That's not the same. The Bill of Rights are specific fundamental rights, where if you read Paul versus Virginia, it'll tell you specifically what privileges and immunities actually mean. Now it is apparent that the right is not specifically granted by the Constitution. Yet, before the 14th Amendment, it was recognized as a fundamental right to the national character of our federal government. Butthurt. I know plenty of people are butthurt right now. It was so decided in 1867 by Crandall v. Nevada, in that, I'm going to zoom in real quick because there's something blocking. Hopefully you guys can see that, but for sure you'll be able to hear me. It was so decided in 1867 by Crandall, in that case, this court struck down a Nevada tax upon every person leaving the state by common carrier. So they're paying to leave, and then they're taxing that person. What you also just should know, what they did is they taxed the company instead. And then, of course, the company raises the price on you. It's indirect, which, you know what I'm saying? It was so... Mr. Justice Miller, writing for the court, held that the right to move freely throughout the nation was a right of national citizenship. That the right was implied not to make it any less guaranteed by the Constitution. To be sure, he emphasized that the Nevada statute would obstruct the right of a citizen to travel, I don't know what the other word, to travel, blah, 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 of of his national government or obstruct the right of a citizen, to travel about, I'm going to say to travel to his national government or its offices, because that's actually a statement that they do use. For you to be able to go to petition to your government in any state where you need to. Or its offices throughout the country. And they give another case. In the United States versus Wheeler, well, that is the citation from United States versus Wheeler. And they quoted Nevada. But there is not a shred of something in the record of the Crandall case that the persons there involved were of any such mission any more than it appears in this case that Duncan entered California to interview some federal agency. The point which Mr. Justice Miller made was merely an illustration of the damage and havoc which would ensue if the states had the power to prevent the free movement of citizens from one state to another. This is emphasized by his quotation from Chief Justice Taney's dissenting opinion in the passenger cases, which I highly recommend you guys read, because it deals with taxing the passenger instead of taxing the company. We are citizens of the United States, and as members of the same community, we must have the same right to pass and repass through every part of it without interruption, as freely as in our own states. Hence, the dictum in the United States versus Wheeler, which attempts to limit the Crandall case to a holding that the statute in question directly burdened the performance by the United States of its governmental functions and limited the rights of the citizens growing out of such functions, does not bear analysis. So when the 14th Amendment was adopted in 1968, it had been squarely and authoritatively settled that the right to move freely from state to state was a right of national citizenship. As such, it was protected by the Privileges and Immunities Clause of the 14th Amendment against state interference. And he's quoting Slaughterhouse. This is how I know people don't read these cases. I have been knowing this shit for a while. And that's for what? Understanding the context of slaughterhouse cases instead of going in assuming I know the definitions and the terminology that they're using. In the latter case, Mr. Justice Miller recognized that it was so protected by implied guarantees of the Constitution that was so acknowledged in Twining versus New Jersey, and Chief Justice Fuller in Williams versus Fears stated undoubtedly the right of locomotion, the right to remove from one place to another according to inclination, is an attribute of personal liberty, and the right ordinarily of free transit from or through the territory of any state is a right secured by the 14th Amendment and by other provisions of the Constitution. Now, because this is of a national character, right? Do you think that this would apply to nationals, right? Those that are not citizens. And it does, because it's of a national character. Nationals are also citizens of the United States. They're just not citizens from the state of the Union. The nature of a passport. American passports contain no evidence of being a license or permit to leave the country. The passport certifies that one person therein described is a citizen of the United States and requests for him while abroad permission to come and go as well as lawful aid and protection. It has been described as a document which, from its nature and object, is addressed to foreign powers. So who are you asking for permission? You don't have to ask. You're not supposed to be need or required to ask for permission from our government. You're supposed to ask the government to the country that you're going to. They do not recognize your right to travel stuff. And they give you some citations. Similar definitions are given in Moore International Law Digest, 1906, Hyde International Law Chiefly as interpreted and applied by the United States, 1922, and 17 Op Attorney General. See also Hunt, the American Passport. I'm going to find that, but I want to find all these things. Right? More international. Right? In the American Passport quoted supra, the American courts have consistently stated that a passport is not evidence of citizenship, which is true because nationals could get that. Duty to issue passports. So this is like almost a repetition to the first video because it's stating things that are more modern now, right? Earlier was a little bit more history and going into back in the day, but this is more modern. The Secretary of State is charged with the duty to issue passports or to cause them to be issued by our diplomatic or consular officers abroad and by the chief executive officers of our inland possessions. No other person may issue passports or papers in the nature of passports. Persons entitled to passports. Only persons own allegiance to the United States, whether citizens or not, may be granted passports. They use the word entitled now. Like as a given, you are entitled to a passport and you can only be denied under due process of law. So you not giving them a social security number is not a due process of law unless you meet the criteria that's requesting for that number. Part 3, federal control of citizens' rights to passports. The view of the State Department is to the effect that the Secretary of State has discretion in the issuance of passports and therefore may refuse a passport to a citizen of the United States. The department's position is briefly set forth in Hackworth's Digest of International Law. It goes as follows. It has been seen from the foregoing quotation that the word may, here we go, may refuse. So here people are under the premise that may means shall and shall means must, or shall means also may and therefore it means must. It does not work like that. Shall will always mean must. Always, always, always. If the word may means must, that means the context makes it obligatory. If it doesn't, meaning what's an example? Like giving the social security number for a passport, right? There's a specific context that they're requesting this number from. If you meet that, right? Meaning the activity that you're doing in real life that triggers that statute for them to ask you for that number, right? Becomes mandatory if those things are in effect. So what is the thing that's in effect? You have to have a foreign residency pertaining to income taxes. In that context, the word may does not mean shall. It will be seen from the foregoing quotation that the word may rather than shall is used, which would seem to authorize rather than require. The Secretary to issue passports. It certainly vests no rights in the applicant for the passport. In considering the question whether certain persons residing in the island of Curacao were citizens of the United States and were entitled to have passports issued to them, Attorney General Hoare, in an opinion rendered June 12, 1869, while holding that the persons in question were citizens of the United States, stated with respect to the citizen to have passports as follows. I understand a passport to be a certificate of citizenship, which is not. That's his understanding. And that a person receiving it is certified to be entitled to such protection as the government can give to its citizens in foreign countries. I do not understand that the granting of passports from your department is obligatory in any case, but is only permitted where it is not prohibited by law, and that's the catch. Right? It's prohibited specifically because of some due process, some question that they are required to ask you, and so forth. The question is, are you required to give them that information? And you know what I'm saying? But it's nonetheless, this quote that he's saying makes it restrictive. They might be using the word discretion and all that shit, right? But it's descriptive. It's restrictive. Not descriptive, restrictive. The question as to the duty of the Secretary of State regarding the issue of the passports to citizens was also passed upon the Attorney General Knox in an opinion rendered in 1901. Two questions were presented to the Attorney General by the Secretary of State, namely, 1, whether the applicant for passport, one Ning Fon, was a citizen of the United States, so that's the question, and 2, whether it, in the event of his being a citizen, it was the duty of the Secretary to issue to him a passport. To be able to return to your home, without them going further now, in my opinion, 100% it's a duty upon them. They don't have the right to restrict your travel. Not arbitrarily. The Attorney General held that the first question should be answered in the affirmative and the second in the negative. But this is that, like I said, that's my opinion. As to the latter, he stated, so he's talking about the second, right? The duty. The act of Congress which defines your duty in the matter of the issuance of passports expressly says the Secretary of State may grant and issue passports. The provision, therefore, is not in terms of mandatory, and I know of no law which gives the citizen a right to a passport. This is in this year. When, you know, like I said, it's mandatory as a given, right? Is not it. It will be mandatory if you fall under all the criteria. All the questionnaires on the application, all that shit. You didn't fail nothing. You didn't lie. There's no due process of law against none of that shit. Substantial reasons exist for the use by Congress of the word may in connection with the authority to issue passports. Circumstances are conceivable which would make it most expedient for the public interest of this country to grant a passport to a citizen of the United States. For example, if one of the criminal class, criminal, an avowed anarchist, for instance, were to make such application, the public interest might require that his application be denied. Without expressing any opinion as to whether a passport should be granted to Ning Fong, I advise you that it may, in your discretion, be granted or withheld. That's his opinion. But to this right here, right, this second part, the criminal class, why would this be a thing? Because he's a U.S. citizen in a foreign country that might be creating a nuisance, a national outcry of something. And that's because of his persona, his attitude, his personality, his violence. Not to say he can't be changed, but hey, all I'm saying is if he doesn't show it, right? Well, I know today it's changing, right? Why? Because you have people that are criminals, let's say nonviolent, right? That are their Second Amendment rights are being restored because states have violated that Second Amendment right protection. Criminal or not, one, they were nonviolent, and two, odds are throughout the hearing or whatever the process is to get to be for that protection to be acknowledged, right? There's no doubt you have to go through a process. They're going to be asking you questions. They're going to know if you've been in trouble or not. Are you still out doing the same retarded ass shit? Like, you know what I'm saying? Like, that's what it's going to come down to. When people have been let free, they've done their sentence, they paid for their debt, they paid for their crime, right? Man, outside of a showing that he's still that class of a person, man, they should not have a right to restrain him for honest protection. The same view was expressed by the Circuit Court of Appeals, 8th Circuit, in the decision rendered April 23rd, 1923, in the case of Miller, Alien Property Custodian et al. Versus St. John. The case had to do with the question whether St. John was to be regarded as a citizen of the United States and consequently entitled to the return of property held by the alien property custodian. The department had refused to issue a passport to St. John because the presumption of expatriation had arisen against them. In commenting upon this refusal, the board stated, so they refused them. And back then, well, for like at least persons that get naturalized, right? They have time limits on you. If you leave the country for 5 years, you're assumed expatriated until you speak up different. It only applies to them. It doesn't apply to like a normal citizen because, well, at least I haven't found nothing that context would apply to a person that's born here. Like if someone was born here and he moved, to England for 20 years, does he lose his U.S. citizenship? I have not found nothing like that yet. Outside of him specifically, acting upon the losing, to lose his citizenship. In commenting upon this refusal, the board stated, but in the case at bar, a finding that plaintiff had ceased to be a citizen of the United States was not necessary to the action of the State Department to denying him a passport, for the reason that the granting of a passport by the United States is and always has been a discretionary matter, and the passport, when granted, is not conclusive, nor is it even evidence that the person to whom it is granted is a citizen of the United States. It's a presumption. It's a presumption. That's why the passport literally on the inside page tells you you're either a citizen of the United States or a national of the United States, which they should just say U.S. national. Sorry, they use U.S. non-citizen national, right? They tell you have to be either one of these two, but at the same time, they could just state U.S. national by itself. Make sure I didn't skip. I did. Look at that. I would have skipped this whole section right there. Okay. This has been the law both prior to the passage of any statute relating to the granting of passports, as well as subsequent to such statutes now embodied in sections 4075 in the revised statutes. But they give you a court case right here too. The department has consistently held the view that the issuance of passports is wholly within the discretion of the Secretary of State, and I know of no instance in which an effort has been made to compel the Secretary to issue a passport. Which, if you guys have read the court case Rubio versus Jordan, they did compel them, and they compelled them on the sole basis of Section 8 U.S.C. 1503 that she was a citizen of the United States. They used words entitled to, right? Entitled unless due process of law. But she was being denied because she did not give enough information to establish her nationality. The court said, of course, she gave copious amounts of evidence. Copious amounts of evidence. This view, respecting the State Department's powers of discretion, originated during the relatively peaceful period prior to the advent of the world wars. Events in general then pursued a liberal course in respect to passports. It is therefore proposed to examine this discretion, 1, in the liberal peace before pre-1914, 2, the non-liberal period between world wars, and 3, the periods of war and national emergencies. And this is ultimately the view that is today, just so you know. But today, with that, I'm going to end this. No, let me keep going. I'm going to keep going. Give me a second. 36. Okay, I could keep going. I want to watch the Bears game, though, too. Okay, since no law of the United States has ever, in peacetime, prevented, the liberal period, pre-1914. Since no law of the United States has ever, in peacetime, prevented a United States citizen from departing or returning to the United States, the Department's view would seem to be consistent with the constitutional rights of the United States citizens. Passports, at least until 1914, were not generally necessary to travel abroad. Therefore, the citizens' constitutional rights and liberties were not, in fact, abridged by the refusal of one. Why is this important? Right? We're not at war. There's no national emergencies, no nothing. These people are leaving whenever the fuck they want. And in honesty, the only people really applying for a passport are government officials or persons going to hostile countries and shit like that. Not a war, but whatever issues we have with other countries. Foreign requirements respecting passports took an increasingly liberal turn, as indicated by the following extract from Rio's article on passports in Encyclopedia of Social Sciences. Shit like that. It's books like that we need. You know what I'm saying? I wish I gave the year. And I quote, the modern system of compulsory passports developed in the 16th and 17th centuries. Such passports were not only a measure of policy, but also a means of protection against the increasing hordes of mendicants and vagrants. Let's look up what mendicants are. Criminals probably too. A mendicant is a beggar. One who practices mendicancy, relying chiefly or exclusively on alms to survive. In principle, mendicant religious orders own little property. So they're talking about religion. It says begging, but they're putting in the context of religion. And vagrants who have become a menace to safe travel. That's what I'm saying. How could this be religious? Beggars for sure, right? In addition, passports were employed to control the movements of special classes of persons, government workers. Thus, they were instituted in 18th century France to enable beggars and vagrants to return to their own country and to prevent their agglomeration. To prevent their agglomeration The meaning of agglomeration is an action or process of collecting in mass. In a mass. So church, like collections at church. To their own country and prevent their collections. And as a safeguard for the secrets of French industry, they were required for artisans who wished to leave the country. In the German states, special passports were required for citizens capable of military service in order to prevent desertion and enrollment in foreign armies. For persons proceeding from territories infected by epidemics, the pest pass, they call it the militar pass, pest pass, and for Jews traveling through the country, Juden pass. That's crazy. But if you know how much they've been kicked out of fucking countries, hey, it's not shocking. You can find the year, right? There's the 1800s. You can see what year they got kicked out of those countries too. Multiple times, not just once out of the same country, but multiple times. The French Revolution brought about a more widespread application and a stricter organization of the compulsory passport system. In the first years of the revolution, the liberal principles which then prevailed led to the suppression of passports. The Constitution of 1791 proclaimed complete freedom of transit as one of the natural, incontestable, and inalienable rights of man. Within a short time, however, the establishment of a severe passport system as a means of control was necessitated by the menace of political immigration and desertion of soldiers and their flight abroad, and the acts of brigandage and the invasions of vagrants, as well as by the requirements of national defense. Accordingly, the National Assembly in 1792 prohibited all persons without passports from traveling in France and from entering or departing. If you notice, though, everything that they're saying has some national context to it. It's not in the basis of some regular schmuck going over here, having a good time, and either coming back or not. The only one that they use is that I just lost a soldier for my army. So far that I've seen, right, that I've read in this book and others. Accordingly, the National Assembly in 1792 prohibited all persons without passports from traveling in France and from entering or departing. Successive laws, especially those of 1793 and 95, confirmed this prohibition and made it stricter. For similar reasons, and in an attempt to prevent the widespread of revolutionary ideas, as well as for purposes of reprisal, and compulsory system was shortly thereafter introduced in nearly all European states, with the notable exceptions of England, Sweden, and Norway. Well, I could understand Sweden and Norway, right? Because that's an aspect of their law, right? The Vikings and all that shit. What's the name of their law? Their form of law? Because they brought, I think they brought the common law with them, right? If I'm correct in saying that, right? In this way, the passport, formerly a discretionary document granted at the request of travelers in order to assure their protection, or at most a document required only of certain classes of persons, was transformed into a compulsory official paper limiting individual freedom and imposed upon all solely an interest of the state. The liberal doctrine, let me make sure I'm on the right page though. The liberal doctrine that the state must not hinder freedom of transit within its territory except when public order necessitates restrictions gradually came to prevail in the 19th century and was even sanctioned in some constitutions. The system of compulsory passports for both internal and foreign travel was at first mitigated and later suppressed except during times of emergency. necessity for travel in connection with increased trade and development of other forms of state surveillance, such as efficient police systems, fast means of travel, and the telegraph, all serve to contribute towards this result. By 1914, the compulsory passport system was abolished in almost all states. In Europe, it operated in Romania, Bulgaria, and Austrian provinces of Bosnia and Herzegovina, Russia, and Turkey. I don't know if that country still exists. Herzegovina. In the latter two countries, right, Russia and Turkey, in the latter two countries, a rigid internal passport system was employed by the police as a means of control and supervision for the purpose of defending the autocratic governments of these two countries from revolutionary attacks. The system survived also in Persia and in Colombia, Guatemala, Haiti, and Uruguay. I know they're saying that by 1914, right? Yeah, I get, 1940, because World War II started, right? You have the revolutionary that happened with the Bolsheviks in Russia, right? So this is still before then. And if you know what happened in Russia, right, with the Bolsheviks, 80+% of them were of those people, and consequently, the result in the next 20 years was like 40 million Christians being killed. There's no other way of putting that. They were killed during that period. Except then, for a brief period during the Civil War, passports were not required by the United States for travel abroad by its citizens, and few obstacles existed to such travel by way of the passport requirements of foreign states. Under these circumstances, the citizen's request for a passport from the United States actually constituted a request for a service from the government to facilitate and safeguard the citizen's own private venture. A venture which the government could, both constitutionally and in fact, achieve without government aid. The exercise of discretion by the Secretary of State during this period could not, it seems, have involved the constitutional right of a citizen to travel, i.e., the right of locomotion. The exercise of discretion by the Secretary of State during this period could not, it seems, have involved the constitutional right of the citizen to travel, i.e., the right of locomotion. Are they saying before, right? Because it says brief period during the Civil War. Well, I guess, yeah, you're right. Civil War. That's the period. For some reason, I was thinking World War I. The non-liberal period between the world wars is the next chapter. And with that, I will end right now, and there'll be a part 3 to this. So hopefully you guys catch up and watch these. I'm trying to make them short so you can burn through them. I recommend, of course, watching them through 1.25 speed or 1.5. I try 1.275. I mean, I do 1.75 when I'm listening into audios, because 2-hour videos become like an hour and 15 minutes instead. So hopefully you guys enjoyed. Please subscribe, please follow. Also follow me on TikTok too. I'm also over there. And this is YouTube for the most part that I post these things on. And of course, come join my Telegram. I'm restarting it for whatever that's worth. But as you guys know, or will know, I'm an asshole and I'm strict. So if you are not there to read, to watch them videos presented, right, you'll probably get kicked in a month or so. So I give everybody a chance. So we'll see how that goes. But take care, everybody. And I hope you please subscribe and like and whatever else. And see you next time.